So now I have the pleasure to call the first panel to the podium. And this panel will be chaired by the third Vice President of the CCBE, Imbe Jürgen. The floor is yours.
Ladies and gentlemen, dear colleagues, I am honored to have the possibility to moderate today's first panel session on the digitalization of justice in the EU. What does it mean for justice systems, and what does it mean for lawyers in particular? Do we all see the future the same way? Well, this panel will explore different perspectives and approaches to the digitalization of justice, as well as the impact of EU measures on justice systems across member states and the legal profession. The panel will discuss what digitalization means for justice systems and lawyers in particular, and reflect on whether there is a shared or divergent vision of the future. I am delighted to welcome three esteemed panelists who will each share their view on this subject. And let me briefly introduce our panelists in the order of their presentations. First, we will hear from Dr. Dominic Gerstberger, who is a lawyer and partner in a private law firm in Austria. And I'm delighted that last year Dominic took on the role of chair of the CCBE's IT Law Committee, which is definitely one of the busiest committees of the CCBE nowadays, when there are so many initiatives and developments going on that need a response from the profession of lawyers' point of view. So we're happy to have you, Dominic, here. Our second panelist will tell us about the digitalization of justice from the perspective of the Court of Justice of the European Union. I'm delighted to welcome Vittorio Bucci, who is the Registrar of the General Court since 2023. You're very welcome, and I'm very much looking forward to your presentation. And last but not least, I'm delighted to welcome Dr. Dirk Staudenmayer, who will present the view of the European Commission. Since March 2023, Dirk Staudenmayer is Head of Unit Digital Transition and Judicial Training at Directorate General Justice and Consumers of the European Commission. Thank you for joining us, and you're most welcome to our event. Well, with this, it is my pleasure to give the floor to our first panelist, Dr. Dominic Gerstberger. Please, the floor is yours.
Thank you very much. Thank you very much. Thank you very much, the audience. Thank you very much, Imbe, for the introductory words. I also want to thank the chair of the European Parliament's Libe Committee and our president for the opening remarks. It is an honor and a privilege to me to be part of this great event and, of course, of this honorable panel. I am here today, as announced, in my capacity as chair of the IT Law Committee of the CCBE. The subject of our discussion, as was already said, is what does digitalization mean for the justice systems and especially for lawyers? Do we all see the future the same way? And of course, me as the chair of the IT Law Committee, I will be happy to take the perspective of the lawyers, as the other two panelists here are much more suited for the perspective of the justice system and the legislative bodies of the European Commission. As this panel and my talk should encourage and provoke discussion, I will abstain from extensively outlining abstract positions on the rule of law, the access of justice, the importance of the independent legal advice, protection of vulnerable groups and those facing digital exclusions, and of course the assurance of a fair trial, especially the equality of arms. I will rather use the time to touch on some specific topics and maybe give one or two practical examples that we as lawyers face each and every day in our practice. So what does digitalization of justice actually mean for lawyers, and where do we see the future? First, let's start with the digitalization that actually has happened. Even though digitalization is a fast-growing and evolving field, I myself as a lawyer has grown into an already happening digitalization process. But my senior partner at our law firm always tells me how he went to court with prepaid stamp marks in his bag to pay the court fees, how he brought applications written on the typewriter personally or by courier to the court. And the only way for getting information was to view court files personally at the court site. Today, I'm doing all this from my computer in the office. I file lawsuits digitally signed via e-filing. I view the court files and copy the court files online. I even send certain applications to the court in a structured form so that the court staff is not obliged to put those informations in manually, but process it automatically. Also, judges do work on completely digitalized files and present court files in court hearings, for example, to parties and witnesses on screens in the room in front of the people, or with consent of the parties, even via video conference. So what does that kind of digitalization mean for lawyers? Mainly, it is an enhancement in efficiency, transparency, and accessibility. And as legal representatives, we of course encourage those enhancements. Digitalization of justice is also making our work easier. It's making supporting clients faster and maybe even better. That's so far as to surprise the European Commission, because in our applications and comments we are sometimes a little more stepping back and asking for safeguards. But this is, on the other hand, now I come to that point, on the other hand, there have to be safeguards as well. For example, while holding a court hearing in a video conference situation, it has to be assured that the lawyer is at any point able to hold confidential correspondence with his client, that the witness heard is not influenced in the remote environment. It has to be assured that the legal representatives are included properly in the ability to access electronic files and communicate with the court via e-filing. We see that still in Austria, that, for example, lawyers in criminal proceedings are not granted proper access to data access in the court files, in the investigative stage of the criminal proceedings. The only way to gain up-to-date access is then to daily apply for electronic access, and that only to find that the application is then approved only days or weeks later. So criminal lawyers, in this specific example, I said I'm going to be practical, introduced the practice that they are having their assistants call each and every morning to ask if there are new findings in the files. Those are only examples of challenges that we have to be met with which affect the legal representation, the equality of arms, and thus the rule of law. On an EU level, and also in some other member states, we do not always see the same digitalization process that I have shown you on my example in Austria. For example, a colleague of mine has not long ago filed an application for a European payment order, one of the main institutions that we are given by the European Union. He had to file it in Romania. And that experience was a lot different than what I described before in my national proceedings. First, thanks to the e-justice portal, he found the information on the competent court and the information about the proceedings in Romania. But then the tragedy started. The application, as there are no means of digital filing, had to be sent first to the Romanian court via mail, signed and printed as we know it from years ago. After a few weeks, he received a letter from the Romanian court saying, of course, being in Romanian, which is not understood in Austria, not commonly understood at least. After translation, he found out that the court is asking him to pay a 200 Romanian lei within 5 days after receipt of the letter, otherwise the application would be dismissed. This was an information that he has gotten 1 day later because he had to translate it, okay? So he had 4 days left, and it was basically impossible to bring that money to the court in time because there was no bank account mentioned on it. Luckily, his client was a bank, and therefore he had the chance to do so. And at last, he made a vital mistake himself. He missed an information that was actually on the Justice portal about the necessity in the Romanian procedure to provide proof in the form of the contractual basis of the claim. And therefore, his claim was dismissed. So we can ask ourselves, what do we want? One option is that Austrian lawyers just abstain from filing applications in Romania or other member states. The other option is to think of practicalities like how can we file applications digitally to European courts or to the other member states' courts? How can a lawyer prove his or her identity on digital applications? And how do we deal with the language barriers? And if you ask me to do a little crystal ball gazing into the near predictable future, we all know that farther ahead it is quite impossible to find out what is coming. I do see nearly 100% of digitalization of the written correspondence within and between courts. Improved cross-border communication between courts themselves and courts and legal representatives. I do see a lot of administrative, organizational and assisting tasks being automized and substantially assisting tools taking the burden off of judges, prosecutors, lawyers and other stakeholders to give them the ability to focus on their core profession. Of course, this does already and will even more in the future involve artificial intelligence, but because this is a topic for the panels coming ahead of us, I did on purpose not go into detail on this. If I may, I do wish that we keep seeing digitalization as a tool and not as an end in itself. It is important to remind ourselves that justice is and must be a human-driven and human-centered process. Thank you very much.
Thank you very much, Dominic. Thank you for your practical insights, and I must admit this very much resonated, and also I've faced the same barriers in my practice, and I believe that many of our colleagues had some moments of recognition here. Well, thank you very much. And now, to have a different perspective on this issue, I'm delighted to give the floor to Mr. Vittorio Bucci. Please. Thank you.
Thank you very much, Madam Chairman. First of all, sincere thanks to the European Parliament, to its LIBE Committee, to the CCBE, to the ELF for inviting me here. And Dominic has tried to be practical. I will also try to be very practical. I will devote my presentation to the efforts that our institution, the Court of Justice of the European Union, has made and will continue to make in order to digitalize procedures and our working methods. I should make two preliminary remarks. Firstly, what I intend to say generally applies both to the Court of Justice and to the General Court. These are the two courts that, as you know, constitute our institution. To a very large extent, both courts rely on common IT tools and have an increasingly common strategy, despite some limited exceptions that depend on certain choices made by each court. Secondly, multilingualism is an important value for our institution, and we are proud to conduct our procedures in 24 different languages. Digitalization is essential to achieving this, whether to enable the automated production of letters, to support human translations, or to make the most of machine-based translation efforts. This being said, let me start with the area that most directly affects the representative of the parties. We've just heard it. This applies to lawyers. This also applies to agents of the member states and of the institutions. I'm talking about the digitalization of the tools through which they can lodge procedural documents and through which our registries can notify such documents or decisions taken by our courts. Since 2011, our e-Curia application has enabled the representatives of parties in cases brought before both courts to exchange procedural documents with the registries by electronic means. Since 2018, this has also applied to national courts and tribunals in the context of a reference for a preliminary ruling. And using e-Curia has been in principle compulsory since 2018 for direct actions before the General Court, such as annulment cases against EU institutions. Until now, e-Curia is not compulsory for cases before the Court of Justice, nor in procedures concerning references for a preliminary ruling, which now take place before both courts. However, statistics show that e-Curia is already used for lodging more than 90% of procedural acts before the Court of Justice, where it is not compulsory. e-Curia has been a very successful instrument, and many users still consider it superior to similar tools that are used in procedure before national courts. Nevertheless, our institution is now envisaging evolving it into a portal for the parties. In addition to allowing deposits and notifications, the portal would permanently and automatically provide certain information concerning the chamber hearing the case, the organization of the hearing, or the development of the procedure. This would render many notifications unnecessary and would allow representatives of a party to consult all documents of the case already served on that party. This should facilitate the management of procedures for lawyers, particularly when representatives of a party change over time. Hearings are, of course, another important area. During the pandemic, both courts swiftly established a remote hearing system, and I'm pleased to say that this system won the 2021 Ombudsman Award for Excellence in Innovation or Transformation. The rules of procedure now expressly allow participation in hearings by video conference for health, security, or other serious reasons, and this takes place from time to time. We are also digitalizing information that we make available to representatives and visitors on the day of the hearing. Next, I would like to mention the contribution that digitalization is making to the transparency of our court procedures. The decisions of our courts are, of course, available on both our website and the EURLEX website with a proper ECLI identifier, which is also used in all our citations. All judgments of the Court of Justice and all important decisions of the General Court are accessible in all EU languages, and all other decisions of any interest are available in the language of the case and in French, which is the internal working language of both courts. Since 2020, the orders by which national courts refer preliminary questions to the EU courts have been published on our website in the original language and in all the other available languages, amounting in general to 22 linguistic versions. Following the recent reform of the statute, we have also made available observations lodged by interested parties. This applies to observations lodged since October 2024 in procedures concerning preliminary references, unless the party that has lodged such observations objects to the publication. Shortly after the closure of each case, we publish all existing versions, meaning the original and the translations of the observations, in the language of the case and in French. The Court of Justice of the European Union also pursues a very active policy in the area of digital communication. Our website offers a wealth of information, documentation, and guidance on our procedures and case law. Since 2022, the Court of Justice has been streaming hearings of its Grand Chamber and the delivery of judgments and opinions. The rules of procedures of both courts now contain detailed provisions about broadcasting, and the General Court has also started broadcasting the delivery of judgments and opinions. Further decisions may soon increase the number of hearings to be broadcast, for instance, hearings of other chambers of the Court of Justice or hearings of the General Court too. The Court of Justice will soon launch a completely redesigned version of its website with a new search tool and will start broadcasting programs through a Curia TV online channel. This is a matter of weeks, if not days. And our colleagues responsible for communication are also active on several social media platforms and will increase their presence further with Curia TV. These steps are aimed not only at informing professionals, but also at bringing our courts closer to the general public and better explaining their functions, their activities, and their contribution to the development of the law. While that aspect may be less noticeable outside the courts, I would like to highlight the decisive contribution that IT tools make to our internal working methods. Our colleagues in the registries use such tools to receive digital deposits, digitalize paper documents, and register them in a database that constitutes the backbone of our work. They analyze the procedural documents lodged in 24 languages, inform the judges, advocates general, and members of their cabinets, and request the necessary translations from the Directorate General for Multilingualism, or transmit them to the Research and Documentation Directorate, which supports the handling of the case, and so on. A common database for all cases available to all court staff was established in the early 90s. Communication between the court members' cabinets and the registries takes place through digital fiches, which replaced the paper ones over 10 years ago. Within the General Court, judgments and orders are signed and filed electronically since 2022. More recently, we have established internal system, a master data management system, in particular to ensure consistency and interoperability between different applications, and an identity and access management system to ensure uniform identity control. However, further progress is needed to improve, rationalize, and streamline our workflows. Very soon, we will deploy dashboards to enable judges to better follow procedures and access and receive procedural documents. Our aging IT tools must be modernized and integrated into an overarching architecture, or where necessary, they must be replaced. Communication inside and outside the institution, as well as document management, will benefit considerably from ongoing IT innovations and projects that we pursue in many areas. If I may add a personal note, as the Registrar of the General Court, I spend a very considerable proportion of my time reflecting on and discussing these developments. Finally, a few words about AI. We are now providing court members and staff with AI tools while taking all the necessary precautions to safeguard security, confidentiality, and respect of fundamental rights. And, most importantly, to keep the judges fully in charge. This is in accordance with an AI strategy adopted in 2023 and with an AI ethical charter that is now being finalized. Since the 1st of October, so just a few days ago, we have deployed a state-of-the-art AI-powered translation tool covering 21 languages. This tool will not replace the translations made by our specialized lawyer linguists, but it will enable quick access to procedural documents for colleagues who do not speak the relevant language. The same tool also provides drafting assistance in 6 languages, which is particularly important for non-native speakers. We also use a speech-to-text recognition system to help prepare hearing transcripts, and we're working to synchronize this system's output with the recording of the hearing, so that this will provide an index for court members and for their staff. Our IT specialists are also developing and testing an AI assistant internally, and they use data and documents controlled by our institution. This virtual assistant will be hosted on secure servers and can be used for various purposes, such as providing summaries, identifying legal provisions and other metadata, automatically segmenting long documents, and in the future it will also support legal research. More generally, we are trying to find ways to integrate AI-powered tools into our working procedures, and we are aware that this will deeply affect not only our internal organization, but also our interaction with the parties, for instance, in terms of the formats and the ways used for submitting or notifying procedural documents, or the way decisions are communicated to the public. Thank you for your attention.
Well, thank you very, very much for this most interesting presentation. It was quite fascinating to hear that indeed the Court of Justice could really serve as a role model for many national court systems, and it was fascinating to hear about these tools that you have already taken into use, and the new AI strategy was of particular interest to me, and it really seems it's worth looking into it in more detail. I'm sure our audience has questions about this, but let's save them for later. Let's hear out also our last presentation, and I'm happy to give the floor to Dirk Staudenmayer now. Thank you.
Well, thank you very much, Chair. Good morning, ladies and gentlemen. It's a pleasure to be here. First of all, thanks to Liebe as the host and to the CCBE for the invitation. I am in a little bit of a dilemma because the Commission will adopt on the 19th of November a new digitalization of justice strategy. But it's not yet adopted. And in the package, together with that digitalization of justice strategy, we'll also adopt a new European judicial training strategy, because that strategy will have a strong focus on digitalization, but it's not yet adopted. So I can't really say the Commission is going to do this, this, and this, because the strategies are not yet adopted. Nevertheless, we had a process, the so-called high-level forum Justice for Growth, where the CCBE also participated, and we listened here to the views of member states and stakeholders and the Parliament, how justice policies can contribute to growth. And in this process, we discussed in the second plenary in June also digitalization of justice. So I'm speaking on the basis of the papers at the time. Now, I would like to start with explaining a perspective, actually our perspective. And that is because Chair Sarzuelas emphasized the advantages, and was very grateful, gives me a nice intro, the advantages of digitalization, and Dominic Gerstberger referred to an often defensive tone in the debate. And that's precisely how I would like to start. So what is our angle on digitalization? First of all, digitalization increases efficiency of justice. Efficiency of justice is a necessary condition for an effective justice system, and an effective justice system is a necessary condition for growth. That's our main angle. The second point is resilience. We have all seen in the times of Corona, and perhaps forgotten too quickly, how difficult it was for courts, for legal practitioners, for all of us to handle the fact that you had put down the computer and go home. I mean, for the Commission, I can tell you it was easy. We had received a year ago all laptops. I indeed put down my computer, took my laptop, went home, started to work from home. But for courts, it was a totally different story. And courts are more important than the Commission because access to a court is a fundamental right. So basically, how to continue to allow citizens to enjoy that fundamental right under the conditions of a crisis like Corona requires resilience. And we need to make sure that if that happens again, we're prepared. So that's the second angle. And the third angle, let me give you an even bigger picture, and that is our geopolitical situation. We have a war in Europe. In a few years, we may have another one, bigger. We don't know. We very much hope not. But at the moment, there's a clear consensus that massive efforts are necessary to strengthen our defense and security. Massive efforts. And that means that the budgets will be under strain. And that includes justice. Efficiency and cost savings are not dirty words, especially not in the situation in which we are now. What we need to make sure is that justice system needs to continue to work, needs to be efficient, even under those budget restrictions, and possibly can even become more efficient despite the budget restrictions. And that's what we're aiming for. We're aiming for that win-win situation. And that's the third and probably most important angle under which we're seeing our strategy. Having said that, let's say what we're thinking about. Well, first of all, we're continuing our existing work. I didn't want to speak about that, but after the little speech by Dominic Gerstberger, I have to say this. I mean, first of all, I'm very, very happy to hear that the e-Justice portal contained all the right and useful information. That's great. Good. I'm very happy to hear because the Justice portal is run in my unit, basically, and we have a team of 6 people doing this, and we're rather busy on that, basically. Now, that's one thing. The second thing is the European payment order. Once the we know it was mentioned in the introduction, we have the digitalization regulation adopted, coming into force. Until 2031, the Commission has the task to adopt implementing acts to make all these 24 fully harmonized civil and commercial and criminal procedures work digitally. The European payment order is one of them. So this is quite an unprecedented scale of work to adopt all these implementing acts and to make them concretely work. And we're working on that, and we will adopt all these implementing acts, and once they are adopted, that won't happen anymore. So that's already one thing. That's good. But we're not stopping there. Now we're thinking about 7 work strands, and I'll quickly run through them. The first one is a sort of something that may sound boring, but is a necessary basis. It's a mapping exercise. We want to find out what is the state of play of digitalization in the member states. And that has several purposes. Firstly, that will allow, we will do this online, of course, that will allow all member states to find out what tools are already in use in another member state. And then you have contact persons. And then basically what you can do is, I want to do anonymization of justice, of decisions. That member state does it already because 8 member states do it still manually. Anonymization of justice, so decisions. So basically, I want to find out, if I'm one of these 8 member states, how that tool is done with AI or IT. And I call that member state and say, how have you done it? Tell me. So an exchange of best practice, that's the first thing which we want to organize. The second thing is, this will serve as a basis for the IT toolbox. What that is, I come to in a sec. And the third is, it will serve as a basis for our budgetary support for the national digitalizations of justice systems, and what that means I'll explain also in a sec. So a rather important first step, despite the kind of boring sounding of it. Second is the IT toolbox. I just mentioned it. So the idea is to have a basket of all tools used in the EU by all member states. They all put their tools in. Because, you know, I don't know if you've read the Draghi report. The Draghi report said that the EU uses 16 different battle tanks and the US only one. And says basically we only need one, really. And the same thing is, for instance, in my example, for tools doing anonymization of judicial decisions. We only need one, or perhaps 2 or 3, but not 27. So the idea is basically that all member states, in the future, hopefully on the basis of open source, put their tools in that basket, and then others can help themselves and use a tool. And you don't have to reinvent the wheel and start from scratch. And for that, we need the mapping exercise, because the mapping exercise gives us the overview of what exists. So that's the second work strand. The third work strand is AI and justice. AI and justice has has many dimensions, but for us, for the moment, 2 dimensions. The first one is the Commission has a big work plan by the AI Act, and we have to adopt a number of guidances. We have already adopted some. For instance, what is a prohibited AI system under Article 5? And there's a very, very important one coming up in February next year, and that is what is a high-risk AI system or AI application. And that will be very important for justice, because the justice sector is a very important use case. And there are many high-risk, but there are also many low-risk. The AI Act doesn't call them low-risk, but I call them for a moment low-risk AI applications. And all those users who use AI in justice will need to know whether they fall into a high-risk category and what they need to do then. And that is what this guidance of the Commission is about. That's done by the AI Office, and my unit in DG Justice is coordinating the input from the justice sector into this guidance, because justice is an important use case, as I said. Second dimension is, we're not stopping there. Because what the AI Act does is a frame. Yeah? It says, this is the law, these are the dangerous things. If you're doing dangerous things, you have to respect those rules, then they aren't dangerous anymore. I'm grossly simplifying, but that's broadly it. No, but that's not everything. Because now member states and judicial administrations need to decide, am I using AI? Which AI? For which purpose? How am I using it in the most efficient way? And that we will have a dialogue with member states, because we have been asked by several member states in the high-level forum, couldn't the Commission develop guidance on this? We'll need to see what the outcome is, but we first need to enter into discussion with the member states and with stakeholders. So that's the second dimension of AI and justice. And that was the third work strand. Fourth work strand is what we call the European legal data space. That again has 2 dimensions. The first one, and I was so glad that Vittorio mentioned ECLI. What we want to achieve is that every lawyer, every justice professional has access to foreign law and foreign case law when they have to apply foreign law. Every lawyer. And how are we going to do this? Well, obviously, we need to make sure that all this stuff is made public, online, in the member states. The court is a model in this, basically, yeah? But the member states, let's put it that way, aren't there yet. Exactly. Yeah? So basically, the situation is, to put it mildly, heterogeneous. Yeah? But how do we want to achieve that besides publishing online? Well, we want to have a systematic rollout of ELI and ECLI, the European Legislation Identifier and the European Case Law Identifier. And then have effective search engines hopefully multilingual, hopefully connected. And so then basically you can search with ECLI and ELI and find every case law you want to have. And that will be a big help, we think. So that's one dimension of the European legal database. The second dimension of the European legal database is seeing it from the perspective of EU legal tech companies. What we would like to ensure is effective access to judicial data. Judicial administrations are sitting like Smaug the dragon in The Hobbit on a huge treasure of judicial data. And they're guarding it equally jealously like Smaug the dragon did. And we would like to make sure that EU legal tech companies have access to this data, obviously anonymized. Yeah? And then can use this data to develop and train AI tools for the use in justice. That's the idea. And that's the fourth workstream. Fifth workstream, video conferencing. Again, two dimensions. Actually, video conference should already exist since May this year. I don't know how many video conferencing is happening in your member states, but since May this year, there's a legal base in the digitalization regulation, and member states are obliged to create in all civil and commercial, and to a lesser extent in criminal procedures, video conferencing facilities. And they're supposed to have national rules. We, at the time, in the digitalization regulation said, should we do that at EU level? No way. We do it nationally. Okay, fine. Let's do it nationally. We said, that's fine. Has it happened? Heterogeneous, to use my word again. Yeah? So basically, we have two problems. The first one is quality, because that court uses WebEx in that member state uses Teams, the other member states uses Zoom, and you name it. And now when we have a cross-border video conferencing and Zoom tries to speak with WebEx, that doesn't work, I can tell you. Or if it works, it doesn't work well. So basically, if two courts try to talk to each other, yeah, and organize a video conference in a cross-border hearing between two courts, it's different if it's a party in a court, then it's easier because the party can use the system of the court. But if two courts are talking or two judicial administrations are talking, it's not that obvious. And then the quality doesn't work that well either. So basically we're thinking about two things. We're thinking about creating, well, we'll see what exactly, possibly a hub or something, a tool, how we can link the existing video conference system in the member states to each other so that they can communicate with each other. And that we come up with voluntary standards, how you should do it. Voluntary, yeah? Not legal. In this strategy, there's, except one, and that's only a sort of an attempt, no legal proposal. Not a single one. Yeah? So basically, we're doing this voluntary, and the idea is that member states can use these voluntary standards when they're procuring video conferencing equipment, for instance. And they don't have to develop it themselves. Or they can use it when they are developing itself. Okay, so these are the two dimensions of video conferencing, and that was the fifth workstream. Sixth workstream, and again I'm referring to what Dominic Gerstberger said, we're thinking about full digitalization of all civil and commercial cross-border procedures, from the launch of the court case to the decision. Now that's a big thing, yeah? I mean, I know that. So we'll have to approach this very, very carefully. We really need to look into this. We need to do that's what we're starting with, a cost-benefit analysis where we need this at all. And then how it's done. But we have a tool already. Because for the digitalization regulation, we have what is called the EAP, the European Electronic Access Point. That is a hub which is developed by us. It is being developed by us, but which will be used as a hub for connecting all these different judicial administrations in these 24 fully harmonized and then digitalized cross-border court proceedings. Or we could use the same tool. We just have to enlarge it, basically. And what we're going to do, we're going to design it that it can be enlarged, but then we have to see what that necessitates. And first of all, it will probably need quite a lot of money. But I come to that in a minute. But then also we need to know where we want this at all. Because let's not fool ourselves. What does this mean? If we have that, it would be highly inefficient to have one platform for cross-border civil and commercial proceedings and one platform for national proceedings. It would make more sense to have one. That discussion we'll have to have in due course. Not before 2028, because we first want to see how the EAP works, and the EAP will be operational in 2028. Then we will have that discussion. And until then, we're preparing it. As I said, for instance, with a cost-benefit analysis. So that was the 6th work strand. And now I come to the 7th work strand. You know, when I briefed my commissioner for the hearings in the parliament here, and I explained to him our ideas at the time of the digital justice strategy, you know what his first question was? And who is going to pay for all of this? And that's a very good question. It shows the best politicians, you know, have that kind of common sense questions. And I've seen quite a lot of, and worked together with quite a lot of politicians in my career in the Commission. So, who is going to pay for this? Well, first of all, the answer isn't easy. First of all, we are still working under the present MFF, the present multi-annual financial framework, for 2 more years. We have enough money for our work. For instance, we have enough money for the implementation of the digitalisation regulation and all the implementing acts. But we definitely do not have enough money for all these great tools which I mentioned at the European level. So, you know, for instance, digitalisation of cross-border proceedings and so on, video conferencing, HARP, etc. We don't have enough money. And much more important is that the member states need to invest quite a lot of money into digitalising their national justice systems. How can we do that? Well, basically, we have 2 legs here. One is, and the Commission made proposals on this in July and in September, the new MFF package. We have 2 legs. I start with the European leg, which was adopted as a proposal in September, and that's the new justice programme. Now, our budget, according to the proposal of the Commission, almost tripled, 800 million. And the idea is to use that budget mainly for 2 things. First of all, for all IT tools and initiatives at EU level, and second, for judicial training. And more judicial training. And then the second leg, and that's the more important one, that is helping member states to finance and to make the national efforts to digitalize the national justice systems. And the tool is, the name is too long, but I always call it the NRP fund, because it uses national and regional partnership plans. This is the mother of all funds with 700 billion euros, and we have some minor competitors like agriculture, cohesion and fisheries in there. But basically we would also like to finance digitalization of justice from it. But that only works, and this is important for you now. This is really important for you. This only works if A, this is adopted, and B, more importantly, the member states then in their national and regional partnership plans include digitalization of justice. If they don't do it, it's over. You know what? If they don't need the money, we're not financing it. That's fine. But if they ask for the money, we're ready to help and to pay. It's quite the big pot of gold at the end of the rainbow. Yeah? So it's a big fund. There's a sizable investment which can be done, a sizable support from member states. They just have to ask for it. And that requires a political decision in your own member states. Yeah? Because, as I said, there are some minor competitors as agriculture, fishery and cohesions. And that needs to be discussed. I'm not saying we will spend more than agriculture or cohesion, of course not. But basically, the national governments and the national ministries of justice and you as the national stakeholders you could endeavor to make sure that it is in. Right. And that was the last one, the last work strand. So, I spoke too long. I apologize. Basically, watch this space. 19th of November, the adoption of the Digitalisation of Justice strategy and the European Judicial Training strategy with a strong emphasis on digitalisation and basically looking forward to future cooperation. Thank you very much.
Well, thank you very, very much. It was all very interesting, and yeah, I could already imagine a picture if this was all actually happening, would be wonderful. But talking about the plans, now we move on to the questions, but I will use my prerogative as the moderator and take the opportunity to ask the first question from you, Dirk Staudenmayer. When putting together these strategies and working on these strategies, please tell us how important is the input from the profession when it comes to the Commission preparing these strategies, and possibly more importantly, what type of input from lawyers, from us, from the legal profession, is of most assistance to the Commission?
Thank you very much for that question. So first of all, the first question, the answer is relatively easy. It's key. I mean, that's why we organized the high-level forum, Justice for Growth. The Commission was listening. We wanted to hear what member states and stakeholders say, including the CCBE. So, key is the first answer. The second answer, that's an interesting question. I mean, obviously, we need that kind of input. The example of the European payment order, that kind of practical input we need. So that's very good. But linking up to what I said before about the funding, I mean, I haven't explained in detail yet how this is going to work, but it's very, and we don't know yet either, because first of all, this needs to be adopted by the European Council. And this is the biggest bazaar in town every 7 years. Who gets how much money for what? Yeah? But basically, once this is adopted, or once we're close to that getting adopted, we need to put this into practice. And judging from the experience from other major financial exercises like the Corona Fund, this is going to work with targets and milestones which we set for member states. And for that, we need first the benchmarks. We need to know where we are. And then we need to identify member state per member state, not in a sort of across-the-board way. No, individually by member state, what needs to be done, because the situation is different in each member state. And for that, we need information. And for that, you could be key again. Because who has the information if it's not you who are working with the justice systems every single day? So the CCBE could be a prime interlocutor for us to collect that information. I hope that answers your question. Thank you.
Thank you very much. We will now move on with the questions from the audience. I already see hands raised. Yes, please, here. You were the first, Ian, and then the next. Yes,
yeah, Ian Mitchell. I'm actually Vice Chair of Surveillance and a member of the IT Committee. But I just wanted to ask Mr. Staudenmayer one question regarding the use by LLMs of judicial data for training, and he added the rider anonymised, of course. Well, there are, of course, a number of states where case decisions are A, generally publicly available, and B, already, and B, not anonymised, except in very rare cases. And a very specific example affecting a member state, I think of Ireland, which together with the United Kingdom has a publicly available a website called Bailey, in which effectively one can summon up pretty well any and all judicial decisions that have ever been made in the United Kingdom or in Ireland. And for all we know, LLMs are currently being trained on a non-anonymized case decisions. So I was wondering if he could expand a little bit on how he sees the LLM training working, given that there may be different traditions of the extent of public availability and non-anonymization in different member states.
Thank you for the question. The Open Data Directive, which is implemented in all member states, gives already companies the right to access to public data. It contains a number of restrictions. The first one is it recognizes and complies with national restriction systems. So it's not terribly harmonizing. It just says, yeah, there are national restriction systems and they continue to exist. Yeah? And then it says you have a right to access data provided that data protection legislation is complied with, which can be done with anonymization. It doesn't have to be done with anonymization. Yeah? Anonymization is just a tool to make sure that the GDPR does not apply. Yeah? That's what is regulated in the recitals of the GDPR, basically. And it says also you can ask for a fee. And for the rest, it refers to national law, which leaves us with a situation which is rather, again, heterogeneous. I don't want to overstress that word. There's even one member state, actually the member state in which we are now, Belgium, which, for instance, prohibits bulk download of judicial data. Just prohibits it by law. The idea is to avoid profiling of judges. That's the only member state as far as we know. But the situation is very, very different. Now, what we are thinking about is, and again, watch this space, the European Data Union strategy will be adopted next week, I think. And there is a possibility in the Open Data Directive to make judicial data a high-value data. And that has, if that is done, that requires a delegated act and an implementing act by the Commission, and obviously an impact assessment, because that's not obvious. Yeah? We need really to see whether we do this. But if this is decided to be done, it has big repercussions. Because that means that there is then, these data have to be made available for free, no fee, with an API and bulk download. And that is a game changer. So basically, if that is decided at European level, we have suddenly overcome all these problems, or this rather pointillistic situation which we have at the moment. So let's see. But at the moment, the situation is we have to comply with the systems the member states have. And if a member state says we're not harmonizing, okay, fine. I mean, that may be a problem for respect of the GDPR. That's not my ball game. But the Open Data Directive is based on the national systems, or built on the national systems. Thank you.
Thank you very much. Take this question from here.
Thank you, and thank you to all panelists for a very interesting intervention. Jana Gajdoshova, Fundamental Rights Agency. I would have a question, I guess, for the Commission, but also for other panelists. I would like to hear their views as well. We heard about the efforts that are put into ensuring that our justice systems are prepared and ready for an online digital world. For instance, drawing on our experience with the situation during COVID, when from one day to another we had to switch to online tools in order to carry on with the life and also with the justice systems. When preparing all the policies and deciding about the actions, what actions to propose for the years to come, are we also thinking about a possible scenario, and the reference was made to geopolitical situation, for instance, where, for instance, EU would be under hybrid military attack, where all our electronic systems would crash from one day to another, and we would have to switch to a paper format from one day to another in order to carry on with delivering justice, in order not to let people be caught in the middle of their proceedings when deciding about very important parts of their lives. Thank you.
Who would like to start? Perhaps you.
Thank you. Well, I will start. Of course, this is a nightmare scenario, but we have to take it seriously. And we do. We have internal work streams to try and imagine what could be done in such situations. And this includes, indeed, going back to maybe not pen and paper, but typewriters. and this is something that the Court of Justice can possibly do because of the scale of our operation, which is relatively reduced. And also, we assume that such situations would not last for very long, and that we could prioritize certain procedures, particularly procedures that have to do with urgent cases. Many of those cases might, by the way, relate to this emergency situation. So it is important that courts are able to rule on emergency measures taken in emergency situations. But, well, this is a very high-level indication. We are thinking about it. I don't think I can go much further than that.
If I may, thank you very much. First of all, I want to highlight that the CCBE is always, and Mr. Staudenmayer knows that from our applications and statements, holding high fundamental rights and especially the procedural rights of our clients. The situation that you're showing us here is, of course, also recognized in the applications of the CCBE, not from that perspective maybe, but from the perspective of digital exclusion and vulnerable groups. So we are also always advocating for alternative measures, not only digitalized communication, but also alternative strategies on that. But of course, I do see the scenario that you have shown from a different perspective as well, and that is one point that I wanted to touch on in this discussion maybe, and that is EU digital sovereignty. And maybe it is also, you allow myself, also a question to Mr. Staudenmayer. I know he's closest to the steering wheels, that's why he's asked that much question, but how do we ensure, and that is a question that we have to ask ourselves, how do we ensure that if we provide companies with all that information and try to digitalize, make justice system more effective, how do we make sure that this is European-centered and this is European companies and European data space that we are saving our data on, and that we are in control mostly? Of course, we are not. You cannot be 100% safe when it comes to cybersecurity risks, but having that control in Europe will be, from my point of view, an important factor. And I know that in the digital justice strategy there is also mentioned digital sovereignty for at least high-risk use cases that we think the justice system and lawyers and legal representatives are always part of. Thank you very much.
Okay, thank you very much. First of all, the cybersecurity question. The legal acts we have at the moment, it's there have been adopted a couple of acts in the last years, apply mainly to the economy. They don't apply to public administrations and not, well, to a certain extent to public administration, but they don't apply to justice. That was at the time decided by the legislator. But member states have realized that there is a problem. We started to discuss this on the Polish presidency at the end of the first semester of this year in the E-Justice Council Working Group. The Danish presidency is continuing this discussion. We need to see. Yeah, I mean, first and foremost, this is member states' competence, and I don't see an appetite from member states to ask the EU to legislate in that area. I see this is part of a general trend, which is at the moment predominant, at least at EU level. You know, there's a ceterum censor, which is no more legislation, no more legislation, no more legislation. And that is why we are in our strategy only putting forward non-legislative measures. We need to see how that discussion goes. It's definitely an important point. But as I said, and we need to see with member states where they see a need. And the second thing is we need to see what happens with the legislation we have. So for the moment, I can't just say it's on the radar screen, but I don't have a good solution to that yet. The other question is, how can we make sure that the data are saved in the EU? A very good question again. The Commission will come forward with a thing which is called the Cloud and AI Development Act. But at the moment, we're that's done by our colleagues in DG Connect. And there are some plans to make sure that there is cloud sovereignty for member states. And obviously, that would include then public administrations, including also justice. I'm not aware yet about the technical details of this, but I know that our colleagues are working on them. We are in contact with them and saying justice is very important. And we are aware that member states are telling us, if you ask for digitalization, we need a digital cloud for justice. I would agree. But how are we doing that? I don't think that my colleagues in DG Connect are planning to put up a EU cloud. But the idea would, from what I understand so far, at the moment is helping, giving guidance to member states to develop their national clouds. But definitely an issue which we are aware of. Thank you.
Thank you very much. I will take the question from the back row. Yeah, please.
Thank you. I'm Philippe Petillon. I'm the head of the delegation of Belgium, but I'm speaking in my own name. I have a question, or rather a suggestion, I'd say, to Mr. Dirk Staudenmayer. I do recognize the challenge of the financing, but frankly, I'm happy to speak to our Prime Minister because he's been very creative lately to find €9 billion to finance new defense initiatives. So I'm happy to talk to him and suggest that he should be as creative for financing justice reform solutions. But I think another challenge is there, and that is the willingness, that is the mindset, that is in our country, and you've actually alluded to it yourself, we very much depend on the willingness of the judges to support the transparency projects that you have, and that allows us to share decisions. They seem to be afraid to share decisions, and I'm talking about the lower level and the higher level. And you know why? Because they actually know that if an appeal is launched or parties call upon the Supreme Court, la Cour de Cassation in Belgium, it actually reflects on their performances, and it has an impact on their reputation and maybe on their promotion possibilities and whatever else. And that is actually something that we suffer from. So we are completely dependent upon their willingness to share information with us lawyers. You suggested that the information was with us. In Belgium, I can assure you, that is absolutely not the case. We completely depend upon the willingness of the judiciary. So my suggestion would be to rather use more mandatory mechanisms than guidance. And I would rather think of directives of regulations to do that, or other means if they exist. I've learned one thing in international relations, that is You have realists and you have idealists. I'm probably a bit of both, but I would very much like us all to find ways to install mandatory strategies rather than suggestions or guidances, because then we will probably be busy for quite some time. And as you said, we need to be prepared for two new problems. If we have another corona crisis like we had 5 years ago, and if we have an escalation of the international geopolitical developments as we know them now. Thank you.
Thank you very much. First of all, great if you could speak to your finance minister and you could tell him, he doesn't have to finance, he just can ask for European money. So that's already the first good news. As I said, the big pot of gold at the end of the rainbow is there if it is adopted. But the other thing is obviously more interesting. And it's very funny what you say, not funny in the sense that I'm laughing about it, but it's interesting to see that it echoes something. We had a presidency conference under the Polish presidency in Warsaw in May this year, and we discussed also European legal data space. And what was remarkable, what I took most remarkable, were two trends. One was reflected in a participant. I said in the discussion, but then we want to make, I explained a little bit what I explained, we want to make access to judicial data. And one discussant asked me in this, do you really want to publish all judicial data, all decisions, and make them accessible? I said, if they are anonymized, why not? Yes, is the answer. And that was, do you really want to do this? It's a mindset thing. You're absolutely right. And then the second thing was, I mentioned my example of Smaug the dragon. I brought the same example. I had this idea when I was sitting on the panel in Warsaw and brought it there for the first time because this was so clear in my mind that there is indeed an attitude in judicial administration. No. My data. Nobody has access. Yeah? And basically, we need to change something. Now, what can we change? Well, the first thing is, I haven't spoken such a lot about judicial training because I didn't have the time. The judicial training strategy will have a strong focus on digitalization and will have 3 objectives. The first one is familiarizing all justice professionals with the tools and the IT infrastructure. The second is to familiarize all justice professionals with the digital law, so the law which has been adopted to the needs of a digital economy and society and has been done quite a lot in the last years. And the third, and now it comes, that's the answer, a partial answer to your question, is awareness raising. Training needs also have the purpose of awareness raising, but people realize that this is not only a trend leaving the station, but it is a necessity. We really need to do this for the reasons I just explained at the very beginning of my expose. So basically, and that is something which they need to understand. And and the second thing they need to understand is if they use this, it helps them. And they will not hear this if I go and tell them, you shall do this, or an IT nerd comes and tells them, you shall do this. No. They need to hear from colleagues. They need to hear from colleagues say, I use this AI tool for my cases, and it really saved me X number of hours in my work. Then we make a difference. So basically, awareness raising is terribly important. And then the last element of the answer is, and the second thing I took from this conference was quite remarkable. It was somebody who said exactly the same what you said. He said, won't work. They won't change their mind. We need laws. If you read the strategy, when it comes out, you will see that we say we want to take as a first approach the voluntary way. Why are we doing this? Because it's the trend of the time. less burden for administrations, less lawmaking. This is, at the moment, the very, very clear political consensus. And then we have to see how it works. This strategy is a new thing. We're coming only forward with non-legislative initiatives. And it will depend on two key enablers. One is money, of course, but the other one is cooperation by member states. And voluntary measures doesn't mean it's less work. It just means you're not forced to do the work. So the strategy will be a failure if the member states are not cooperating. But that is also a lesson we can learn then. But at the moment, I can tell you, it's politically impossible to come forward with legislation. So we have to try it this way. And then we'll see whether it works. If it works, we're all brothers and sisters, and we've achieved our objectives. And if not, then we have to think again.
Well, thank you. I'm afraid I will have to take the last question now, and let's try to keep it short. Thank you. Please. Yeah. You were first. Or... Yep.
You wanted to?
Yes, please. Thank you.
Thank you very much. Ivana Frutov, the English Bar Brussels office. I actually wanted to take this in a slightly different direction, but very, very quickly. We understand, obviously, that the United States has been issuing sanctions against the judges and prosecutors in the ICC. I was there last week and discussing it with members of the court. And now there's a potential threat that the entire court might be subjected to sanction. The impact of that has, for me, it's really revealed itself in the last in those discussions, potentially not being able to access Outlook, your own server, your own document database, because it's being controlled from suppliers who are United States subject, therefore, to the sanction. With that in mind, one can understand reticence to go down the sort of routes that you're talking about. What can we do? I guess it goes back to cybersecurity, but it's a slightly different element of cybersecurity. What can we do to be more resilient in the face of that type of unexpected but really realistic threat now?
Sorry to that. Young man from the German delegation. Building up on this, there's one issue. We do not have, and you're talking about money, for instance, but we do not have the real providers for such a uniform system. Is it not first necessary to build up European providers who can do that? Because I can't see anyone.
Maybe just as a quick reply to the last intervention, it so happens that the Court of Justice was able to find European providers for its AI translation tool. It's a German company. It uses servers that are based in Europe. It's controlled by European interests. And we have obtained a number of additional contractual safeguards so that our documents are not visible to the company and cannot be used by the company for further training of their system. So this is possible. We are doing something similar with the development of our AI assistant. We are now using a European cloud provider, and we have all assurances that our data are not accessible outside the European Union. But you're right, there is a problem of scale. Of course, we can do it because we are a relatively small institution. There is indeed a need to have more and better European providers.
Mr. Chairman, I'm terribly sorry to interrupt, but I think that didn't get the point. It was discussed yesterday at the CCBE. The issue is not where the data is stored. The issue is the client end. So if you use Outlook for your email, no matter where your email is stored, it's susceptible to US supervision. I'm terribly sorry to interrupt, but I do think that's a very important point.
Thank you very much. Thank you very much, Ian, as well. The problem we have discussed already yesterday. I do also see an issue. Thank you for our German colleague there. That we are not yet at the level where other states like the US or even China are in the field of AI and providing those applications. And I feel like there is the need to Europeans to step up on that game. And I also know, we all know, that there are initiatives funding AI hubs and infrastructure coming up, but still, when we look at this from the perspective of AI, there is even more than in the cloud area a huge problem because the AI models that are always behind the AI systems are at least those that are really capable and the strongest AI models are mostly coming from foreign countries like the US, GPT, DeepSeek from China. Those are very powerful applications, AI models. That and there is. I don't want to say that there is no European pendant to this, but still there is room to step up, and we in the CCBE and the IT Law Committee, we are trying to get our colleagues informed about possible alternatives that come from Europe. And we will be working on this and trying to inform and also intervene where possible. Thank you.
Well, thank you very much. I mean, this is obviously much beyond my realm, but I mean, I know that the Commission is doing quite a lot in that area. I mean, the Commission will adopt at the end of this month an Apply AI strategy. There will be the Cloud and AI Development Act, which I mentioned earlier. So all these instruments are intended to promote the use of AI by non-legislative, voluntary measures and to help the European industry to blossom in that area, basically. The President also announced, I think it was in the State of the Union speech, that we will look at public procurement law, because that's the important bit, yeah? Because at the end is who procures and under which conditions. You know, if judicial administrations go for Zoom or WebEx, then yeah, they may have a problem basically if that is an important point for them. But there are on the market alternatives. Yeah, and the Commission overall is definitely trying to help all these European companies to develop. And we're trying to help, to advise those who procure how to do that, how to create that. But after all, at the end, this is a market economy. So basically, it's not something where we can create a European enterprise and basically said, now you all deal with them. So there are limits, basically. But I can tell you that the Commission overall is doing a lot in this area.
Well, thank you very much. With that, we will have to conclude our panel. There is a coffee break for us ahead. Thank you very, very much. A big applause to our wonderful panelists, please.
Yeah, also a warm thank to the moderator for excellently leading this panel discussion.